Good morning. This is Joe, the advocate, and thank you for joining us. Happy spring, everyone. We missed a few minutes, so we're diving right in. We are going to begin before there's ever an incident, before anyone's ever sick or injured or worse. How do we prevent these things from happening? Well, one of the most effective, least effort, and free ways to do it, frankly, is why don't you form a labor management safety committee in your workplace? It's a very simple idea that essentially boils down to people talking to each other, okay? So you're going to have your management and your labor, if you want to think in those terms, and maybe pick an equal number of each. Pick a chair, rotate it, the chair, have a regular meeting, show up with an agenda, talk about the places in the workplace that might be creating incidents. Either they are or they could. So you're trying to mitigate an incident before it ever happens. You might want to review your equipment. You want to make sure your equipment is maintained and you're using it properly. You might want to review your workflows. Are you sure you're doing everything in the safest possible manner? Who's doing the training also, by the way? Is that person reliable? Does that person know how to train safely? Is that person comfortable training? The idea here, my friends, is to simply think to yourselves, are we doing things the safest way possible? And if not, let's change it before somebody ends up in an emergency room or worse. All right, the workers' comp system. It is a no-fault insurance system. That means that there is insurance somewhere in the mix that is going to pay the claims should there be an incident. The board does not pay the claims unless. We'll talk about that more in a moment. But the employers have to provide this coverage by law just in case there's an incident. The workers do not contribute directly to the cost of this incident. To the cost of this insurance either. And it is your right as a worker. You can't negotiate it away. You can't sign it away. This is yours. It has to be here. And as a matter of fact, you can think of what I'm saying to you as a floor, as a minimum benefit, okay? I'm going to be discussing the things that the law mandates that we must or you must provide. It is certainly possible to negotiate a richer benefit, and that does happen as well. Immigration status. Let's address this one right off the top, or right at the top. Immigration status of the worker is not a factor in this system, period. It's one of the few categorical statements I can make about workers' comp. No one is asking where the worker was born, how long the worker's been in the U.S., et cetera, et cetera. It simply does not come up, period. Finally, sometimes immigrants do speak languages other than English. Well, guess what? We have language assistance available gratis at no charge for the workers. Ali is showing you our webpage here where we explain how you go about getting this assistance and the languages that we do have our materials readily available in. There are, I think, a dozen languages beyond English where we have materials ready right now. And if a worker should ever wish to speak with us in a language other than English, that's fine. You just have to let us know, and if you have a hearing, we will put a translator or an interpreter, I think it's an interpreter for spoken. We will put an interpreter on the line to translate for the worker at no charge. You just have to let us know. We certainly can do Greek. We had that question come in. We don't have the documents ready in Greek because that's not one of the 12 most spoken languages in New York right now. But yes, we certainly can do Greek. And the 12 languages where everything is already available, that's well over 90% of all speakers in New York. We had a question come in about safety, so as long as we were there, how would you suggest we create safer workplaces when people are working at home? That's a pretty good question. I would suggest you go conceptual at that point. Instead of looking specifically at people's homes, which you wouldn't be able to do, I would suggest you start thinking of safe concepts of safety that people can then use in designing their own home workplaces. And then, of course, as long as you have those, why don't you make sure that your established workplaces conform to those as well. All right, what's the Workers' Compensation Board? Well, that's a New York State government agency that Allie and I are dedicated employees of. We are the regulator of the workers' comp system. So we're not the payer, but we are the regulator thereof. We have close to 1,000 employees and about 24 offices and hearing points across the great state of New York. How do we do our job? Well, we receive reports of incidents. We receive the medical documentation. We're supposed to receive all of the paperwork related to an incident and the comp claim, and then it gets put into our files. That enables us to do our role efficiently, and it enables everyone to see what's happening. One of the things that we do that is most prominent is we will hold a hearing when it's appropriate to move a claim forward or to adjudicate a claim, as it's called. So we have administrative law judges who will make decisions in claims at hearing when necessary, and we will talk more about that toward the end of our session today. Who is this advocate for injured workers? Turns out it's me. That's my informal title. My civil service title is actually ombudsman. An ombudsman, or an ombuds as we're now largely known, an ombuds is a person in an organization who is who's there to care about the health of the system, to monitor the health of the system and the sanctity of the system. Are things moving the way they ought to? Is the system working as it ought to function? That's what an ombuds is concerned about. And for my role, I am concerned about the workers' experience. That's what makes me the advocate for injured workers. We have another ombuds here, a fine fellow who is the advocate for business. And he's concerned about the employer's experience. And he also does webinars, by the way. So if you want to see the advocate for business webinar, the entry level that he does, I believe that he tends to do those in the first week of the month. So go to our webpage where you registered for this one, and you can register for his. So in my office, we have a group of people, and we help workers with the more difficult and complex claims, and that certainly includes fatality claims, and we will be talking about the fatality benefit because there certainly is one. I also work directly with the 9/11 community, and we'd like to show you a little bit of assistance for 9/11 responders because that situation is ongoing, my friends, if you don't know that. You can see in front of you these 3 benefit areas. Overall, just so you know, overall, the people who responded to the World Trade Center and who helped do the rescue, recovery, and the cleanup, if they were paid employees, they're part of our system as workers' comp pertains to them, okay? On the far right, though, you will see something called a volunteer fund. Well, this is the only instance in New York State history where volunteers can qualify for workers' comp benefits. So there is a comp benefit for those folks, and that part of our webpage will get you to where you can learn about that. In the center, you see September 11 Victim Compensation Fund. That is a fund that is maintained by the Federal Department of Justice, and it can provide compensation for those individuals who did suffer harm or whose family or who lost a family member. So we would encourage you to visit that site and learn more about that if that's you. And then finally, the World Trade Center health programs on the far left. The federal government has provided a great deal of money to operate these wonderful health programs across the country, focused in New York, obviously, but they are across the country as well. So if you were impacted by the World Trade Center events, you should really register with the World Trade Center health programs. Go for the monitoring of your health. That's free, my friends. And then if you have a condition where you need treatment, the condition is going to be treated also at no cost to you. And of course, I do report directly to the chair of the agency. That's an essential feature of an ombuds. You have to deal with the person at the top. All right, new concept now. We're getting into it. Who pays your workers' comp claim? Remember I said this is a no-fault insurance system? Well, that means there's an insurer somewhere in the mix. And this is going to go down one of two roads. There's either going to be an insurance policy or there's going to be self-insurance. If there's an insurance policy, and this is 2 out of 3 times, okay, 2/3 of the market has an insurance policy. That means that one of the 280 insurance companies who are licensed to write comp in New York wrote a policy and the employer bought it. So that means if you're a worker, if your employer has an insurance policy, you are going to be dealing with the insurance company if you have a claim. You're not going to be dealing with your personnel or human resources. Your supervisor or your manager is not going to know anything about your claim. You're going to be dealing with the insurer. They pay the benefits, and frankly, they're driving the events in your claim. Now, 1/3 of the time, the employer is self-insured. That means that the employer has the financial resources to set aside funds or have funds available to pay your claim directly. Governments tend to be self-insured in New York. They don't have to be, and not all of them are, but they tend to go for some form of self-insurance. I'm talking about cities and counties and school districts. There are also about 90 very, very large private employers in New York who are also self-insured. Now, when I say very large, I mean multi-billion-dollar corporations. Okay, you need that type of reserving. But they have gone through a process with the board where they're also self-insured. We make sure that they can do this properly. They post collateral. The point here is, if you're dealing with a self-insured employer, you are almost certainly going to be dealing with a third-party administrator who's handling your claim. So again, your direct supervisor in your HR department, they're not going to know anything about your claim. You're going to be dealing with a third-party administrator, a claim administrator. The biggest self-insured in the state of New York is the city of New York. The city of New York did not hire a third-party administrator, though. They created a whole section of employees known as the law department. So they have a whole group of dozens and dozens, at least, of employees of New York City who actually handle the comp claims. I'm only calling them out because New York City is by far the largest self-insured employer in the state. Finally, remember I said the board does not pay claims unless, well, let's say the employer should have had insurance but did not. Now we're into the unless. The board will advance the payment and then bill the employer personally. So this is a really good point to say. If you have a business, my friends, you really need to be carrying that comp insurance if you're supposed to have comp insurance. And we'll talk about who's supposed to have comp insurance in a moment, but spoiler alert, it breaks down. Do you have an employee? You should have comp insurance. When I say we advance the payments, what that means is if you're the worker, you file a claim if you get injured on the job, period. You don't have to worry about whether your employer has insurance or not. If they do, it's a great idea to find out who the insurer is. We'll talk about that in a moment. But you file the claim, okay? Don't shut yourself out of potential benefits. That's the lesson here. File the claim. Now, who needs that insurance? Well, we have for-profit businesses, we have nonprofits. If you're a business, which means you're for-profit, if you have one part-time employee, you need insurance. If you have one part-time employee who's your niece, who only works for you during June, July, and August when she's home from college, you need insurance, okay? It's really that simple. There are no exclusions. The only exclusion really has to do with a family farm and the children of the farmer. That's about it. So everybody else, you have a business, you have employees, you should have a policy. If you're a nonprofit, you probably need the coverage as well. Here's how that breaks down. Let's stick with the nonprofit. Any compensated individual at a nonprofit can be determined to be an employee by us, the board, with limited exceptions like clergy or teachers in a 501c3. Okay? So anyone else at a nonprofit, you could be considered an employee. You probably should have the insurance. If you're doing a services for a for-profit business, as I said rather colorfully a moment ago, yeah, you could be determined to be an employee. Now, how do we, the board, because we determine who's an employee, how do we determine who's an employee? It's a great question, Allie.
That is a great question.
Okay, here's what we do. We are going to use a test that essentially boils down to what we call direction and control. Is the prospective employer exercising direction and control over the activities of the prospective employee? If the answer is yes, then that person very possibly might be considered an employee. Now remember, it's the comp board who's determining it. What that means is, number one, your friend Christina said you're not an employee because you work for that ice cream stand, you're an independent contractor. You don't listen to your friend Christina. Or the employer said it, you don't listen to the employer. Or you got a 1099. Here's the really important thing to know. There are about 5 different government agencies I can think of who are concerned with employee status. There's the board. There's the Federal Department of Labor. There's the State Department of Labor. There's the Federal IRS. There's the State Department of Taxation and Finance. That's 5. We all care about who's an employee, who's an independent contractor, but we all use our own law in making that determination. So that means you absolutely can be an employee for comp purposes, but you can be an independent contractor for tax purposes. So you can get paid on a 1099 and still be an employee for comp purposes. So we will make that decision. And this does potentially include internet businesses, okay? Just because you're working with an internet-based business does not automatically mean that you're an independent contractor. Go ahead and file that claim, and we will decide if we have to. Because you don't know, your prospective employer might realize you're an employee and just accept the claim. There are internet businesses who are quite prominent who are carrying workers' comp policies, I can reliably tell you. Oh, we got ourselves a question. What does it say, Allie?
Well, related to this, someone's asking about setting up a claim with DoorDash, which is kind of similar to the internet businesses we're talking about.
Oh, okay. If you work for DoorDash or any other internet business and you got into an accident while doing a delivery, file a claim. We are going to talk in a little bit about how to file a claim. Just write down the phrase C3, okay? C for claim -3, you're going to file a C3. We're going to talk about how you do that. We have a bunch of questions. Why don't we just do them right now, Alex?
Sure. What is the time frame to file my workers' comp claim?
2 years. We'll give you more detail on that in a moment. Let's do the next one.
If we are working ourselves, do we need to get insurance?
Okay. If you're working for yourself, sole proprietor, you can buy insurance. You don't have to, but you certainly may. And this is a really good question. I'm glad we got this. I'm glad you read this question now, Alex. Here's why. Yes, if you're the sole proprietor, you can certainly buy insurance because you might realize, let's say you do get hurt, what are you doing for income? What are you doing for medical care? Okay, but also, let's say you are the business owner and you have a few employees. Sometimes the business owners will exclude themselves from coverage to save a few dollars. You might save a few $100, let's say, over the course of a year. You can, as the business owner, choose to exclude yourself. But again, I really think you should ask yourself that question. Suppose I get hurt. What am I doing for income? How are my medical expenses going to be paid? Because I'm not going to give you too much detail, but those of us in this building where we work, we know the story of a business that happened on this street where the business owner, it was a restaurant owner, he actually was killed at work and he had excluded himself. So this is a bit of a cautionary tale. If you're the business owner, think long and hard, please, about the sensibility of excluding yourself. All righty. What do you do if there's an injury? Okay, workers, number one, our mothers were right. Take care of your health. Get the necessary medical care now. If you're an employer and you want to help your employee get to a doctor, great. Thank you very much. No, you don't have the right to direct your employee to a specific facility if there's an emergency. I'm sorry you don't. And I'm sorry you don't have the right to be in the exam room. If the worker wants you in the exam room for some reason, they can let you in, but they don't have to. The only reason I'm saying this is because I do get this question about once a month pretty reliably. So I'm sorry I had to put us in that place, my friends. But go get the necessary medical care. Then tell your employer in writing that you had an incident. This is an extremely important thing to do for two reasons. The first reason is, well, the law wants you to do it. But the second reason is, once you do this, the employer has to tell its insurer, who has to tell us. And if that doesn't happen, penalties can and do result. You see, it starts the flow of events, the chain of events that yields to a claim. That's why this is so important. So you tell your employer in writing. I would suggest you use a document, like a piece of paper, or an email. You can text it. I don't recommend texting it, and the reason I don't recommend you do that is you might have to show that you did this in 11 months. And I dare you to go on your phone right now and find a text you sent 11 months ago. Seriously, your phone's default settings are save text for 30 days. I don't know if everybody realizes that. So you use an email if you can, or a document. Then what you do is you file a C3. We had that question before. How do I file a claim? Well, file a C3. There are two ways to do it. Number one is you can do it on paper, perfectly fine. But if you can do it online, Allie is showing you our website where this is how you file it online. These are the things that we're asking. Your name, your address, and then all of that demo stuff, and then your employer info, who'd you work for, what did you do, were you full-time, part-time, and also, by the way, if you have a second job, guess what? You include that info here, because even though you got hurt at the Price Nursery, where, you grow flowers all day, well, your night job, you're a programmer for Struble Security, you need to put that job down too, because if you can't do one, you can't do the other as well. Okay, so that's the C3. Continue getting your necessary treatment. You have 2 years after incident to file that claim. I'm recommending you do promptly, like the next day maybe. Make sure you tell your employer like the next day, because employers, make sure you tell your insurance companies like that day or the next day, because if those benefits don't start flowing in 18 days, or 10 days from when you learned of it, a penalty is going to happen. All the insurance companies are cheering right now because that's their number one thing. Please tell us.
All right, now we have a poll. So questions for you guys. Should Kadir file a workers' comp claim? So Kadir is not an American citizen, is in the U.S. on a work visa. He works 40 hours a week on site at a software company at an assigned desk using the company's equipment on tasks the company assigns. Kadir works 8 hours per day, start and end times vary, and is paid on a 1099 so the software firm considers him an independent contractor. One day, Kadir is inattentive and drops a computer server, fracturing his left leg. The employer calls an ambulance that takes Kadir to the hospital. So, should he file a workers' comp claim based on this information? Yes or no? Poll is going, so we'll give you a couple seconds to answer. It looks like a lot of yeses, Joe, a lot of yeses.
Keep them coming, my friends. Keep your answers coming. There are 114 of you on this session right now. I'd like to see at least 60 responses. That would be 1 out of 2.
Almost there, almost there. What do you think?
Okay, when we get to 60.
All right. Almost there. We see a lot of yeses here.
Give me one more. Come on, gang. Yeah! Okay, Allie, what happened?
All right, so almost everyone said yes. What do we think of that?
Thank you for participating. Thank you for your responses because, it was 63 to 2.
Mm-hmm.
Okay. Yeah, we also think that Kadir should be filing a claim in this instance. Mm-hmm. The important things to consider are he was working and he got hurt at work, and he clearly got hurt. He needed medical care. The employer called an ambulance. So, by the way, that could be construed as the employer having notice of the incident. Thank you for calling the ambulance. We put in some red herring here to see if we could get you off the track. He's not an American citizen. So what? Mm-hmm. He's on a visa. So what? Remember what we said about immigration? Okay, he's working at the company on site 40 hours a week using their equipment on tasks they assign. they call him an independent contractor, that's great. But that doesn't mean he really is for comp purposes. So the point is, file the claim. The insurer might just accept it. But if the insurer does not just accept it, then the board will make the decision. So we're all about filing the claim. Now, there are two types of benefits and then the fatality benefit. So first we're going to consider what is the medical benefit under workers' comp? Well, it is care for your comp injury or illness or the body site that's been impacted. It is at no cost to the worker. It is a lifetime benefit. I'm going to repeat that because it's so significant. It is a lifetime benefit. So you hurt your leg, you hurt your left leg at work, it's established left leg. The care for that injury that is affecting your left leg is yours for the rest of your life. You don't need to do anything special about it. So let's say you established your claim in 1999. Is it hurting today? Are you having an exacerbation today or a flare-up today? Go to the doctor. You don't need to do anything special. And these are all the medical expenses from the surgeries or inpatient or outpatient or office visits or physical therapy or equipment, medication. We're talking about all that stuff. And then finally, there is transportation available. Transportation costs are reimbursable to workers. You would use Form C-257, okay? And it's a very simple process. Let's say you're going for medical care once a month for 6 months. You would just know where did you start, where did you go, and where did you finish, okay? And you just put that on the C-257 form and file it. If you drove, we're using the federal IRS rate. So it's about 65 or 67 cents a mile. It's published on our website. You can get it. If you took an Uber, you could submit that bill. If you took mass transit, okay, you're in New York City and you took the subway, I think subway's still $2.75. I'm sure somebody will correct me if it's not. But let's say you take the subway to and from, fine, just note that, and that's a good $5.50 coming back your way. So be sure to file that, my friends. Here's some best practices for medical care. First, the bottom of your screen. You're going to an appointment. Subway is now $2.90. Oh, dear. Okay.
Oh, my.
Something told me that got up. We're obviously not in the city. Yeah. If you're going to medical appointments and you're an injured worker, do your doctor's office a big favor. Show up there with your WCB claim number. Okay, we're going to give you a claim number that's going to be 8 characters. It very possibly might start with the letter G, like glorious. It doesn't have to, though, but it very possibly might. Bring it. Also, bring the name of the insurance company who's going to pay this and bring their claim number. Your doctor's office will love you. Also, if you are in temporary land, let's say your injury is temporary right now. All injuries are considered temporary unless they're so severe that you suffer a permanent disability. But when you're in temporary land, I'm calling it temporary land, when you're in temporary status, you need to go to your doctor every 90 days and get a degree of disability. That means how disabled are you? Because if you're more than 0% disabled, there's going to be a benefit payable to you. And you need the doctor to say how disabled you are every 90 days. If you don't, then we can't do the equation that yields how much money you're going to get. We'll talk about that more in a moment. So understand this degree of disability. let's say you're requested to go to an independent medical exam, known as an IME. Well, this is the insurer asking you to see a doctor that the insurer is paying to give an opinion on some element of your claim or your health. This doctor is not treating you. You're not going to get a treatment recommendation. You're not going to get medication prescribed. And what that also means is there is no doctor-patient relationship. Anything you say, even in your small talk, can be noted and reported. So, here are some other things you should know as the worker. Number one, you may bring a witness. Don't let anyone tell you no, you may. You or your witness can record the IME exam, the independent medical exam. If you have a cell phone, you can do video and audio. Your witness might do that. This is a good thing to do as a worker because you're going to get a copy of the report that's generated, and you can check the report against the video and make sure all the findings that are in the report are visible on that video, as in they actually happen. Now, let's say you have an attorney. If you see a discrepancy, definitely bring it to your attorney's attention, because your attorney's going to want to know, but also because the attorneys are pretty knowledgeable. They're not doctors, but they're pretty knowledgeable. They might be able to recognize a range of motion tests when a layperson doesn't. Okay, there is that. But let's say that there is a complaint. Let's say, no, nobody sees where this finding is coming from. Or, you were examined in the waiting room and not in an exam room. That has happened. You can make a complaint about the conduct of the IME, and you can make that complaint to the Advocate for Injured Workers. We will have my office's contact info on screen at the end of this, okay? You're going to make that complaint essentially to me. I'm going to triage it and almost certainly pass it on to the health provider discipline unit, because we do take these things seriously, and we did actually remove the license of one of these IME companies to operate about 2 years ago now, because they were doing some very naughty things. Finally, you can claim travel reimbursement to and from this exam. I would encourage you to do that. Now we're going to talk about the indemnity benefit, the lost wages. Technically, we call this the indemnity benefit. Let's say you got hurt and you can't work, or you have enough of a disability that you're qualifying for an indemnity benefit. If you are not working and you have a 1% disability, you're going to qualify for indemnity. So how do we calculate this? How does this work? Well, it's 2/3 of your average weekly wage. Your average weekly wage is what did you earn per week on average over the 52 weeks before the incident. So we look back 1 year. All your compensation counts. That's why I mentioned a second job, but that also means your overtime, your bonus, your uniform allotment. You get $100 a month for uniforms, that counts. You're the superintendent of a building in the Bronx and you get a free apartment. That apartment has a value, that counts. Okay? And then your benefit at the maximum would be 2/3 of what you were earning on average. So if you were earning $900 a week, 2/3 of that is $600 a week. That'd be your benefit. The benefit rises every July, adjusts every July 1st. It has just so happened to rise the last 15 years it's been going on, or 14 years, sorry. But it's July 1st, it adjusts. Right now on screen, there's your maximum 1145.43. The current minimum is $275 a week, and it's going to increase on January 1st to $325 per week, and then after that it'll index again, like the way that the maximum does. The maximum and the minimum in the future for the minimum, but the maximum today, they're pegged to the average pay of the average worker in the great state of New York for the preceding year. But when it comes to the minimum, just want to note, it's $275 per week right now. If you actually earned less than that and you're going to get the benefit, you're going to get what you were actually earning, okay? You're not going to get an increase to $275. And this is all tax-free. All the benefits are temporary at first. If you suffered a permanent injury, you'll either have a permanent partial benefit or a permanent total benefit. Let me just explain for a moment how that works. In order to determine whether someone is going to qualify for a permanent partial or permanent total, the worker has to arrive at a place known as Maximum Medical Improvement, MMI. It means just what it sounds like. You're as well as you're ever going to get. Okay, so hopefully you're 100% healthy. Let's say you're not. If you're less than 100% disabled, you would be permanent partial, and then you could get between 4 and 10 years of benefits. But if, I hope this doesn't happen to you, but if you are permanently totally disabled, then you would get those payments for life. You get the maximum amount you qualify for life. We definitely spend a lot of time on this in the Workers' Comp 202. If you're interested in more detail for the Workers' Comp 202, we are about to post new dates on the web page. So you can certainly register for that. There are also payments for the loss of use of a limb, okay? Let's say you got injured. Let's say you broke your arm and you didn't recover 100%. Let's say the doctor said, well, Allie, I'm really sorry to tell you that you are at maximum medical improvement. It's been 18 months, because these things do take a year, 2 years, 3 years for you to get as well as you can. But the doctor said, Allie, I'm sorry, but you've lost 10% of the use of your arm. Well, there's a benefit for that 10% loss of use, and this is a limb. So if you've ever had a comp claim and a limb has been affected, did you recover 100%? Because if you didn't, you need to go to a doctor and get an exam. You could possibly be able to pursue the schedule loss of use benefit. And by limb, we mean arms, hands, fingers. Each finger is worth a different amount of benefit. We're also talking leg, foot, and toe. Each toe is a different amount. We're also talking about vision, hearing. Occupational hearing loss is it is the most overlooked benefit in the system. There are thousands of people, in my opinion, who have lost hearing due to employment who never claimed an occupational hearing loss benefit. And then finally, facial scars. You can also have a benefit for that. Oh, and finally, I always like to say this, please note where you were working when you got injured. This is really important if you're working in a very remote farm, or if you're in a city and you're doing construction, maybe you're a day laborer. Please note the address where it happened, because if you file that, we can pull the building permit, and we're probably going to save you months of hearings to determine who the payer is. Also, direct deposit, OMG. If you're getting payments, would you please consider direct deposit if you can get a bank account? Step 1, can you get a bank account? Do you have one? Step 2, please consider direct deposit, because it eliminates all those missing check, late check inquiries that we all get. Also, if you get paid in cash, that's fine. Just keep a record of it. Get a notebook, open up a file on your phone, and just write down who paid you, how much, for what service, on what date. Those records might be invaluable to you if you have a claim. The last major benefit we're going to discuss is the fatality benefit. A worker perishes either on the job or afterwards due to employment. There is a benefit. The funeral and memorial expenses are reimbursable. You can qualify for up to $12,500 in the traditional downstate area, New York City, Long Island, Westchester, Rockland. The other counties of New York, $10,500 is reimbursable. The surviving family are the first people in line for the benefit. We look first for lawfully wed spouse, gender, not relevant, we don't care. After spouse, we look for children, up to 18, great. If they're between 18 and 23, the children of the deceased, this is of the deceased now, they would have to be in higher education. But we also look for any disabled or blind dependents. They can get it for life. The spouse, the disabled, blind dependents can get this for life unless they remarry, so that's only the spouse. The kids are 18 or up to 23 of college. If none of these people exist, $50,000 is payable to the parents of the deceased worker. If none of those parties exist, $50,000 is payable to the estate of the deceased worker. The benefit is calculated in the same way as the indemnity benefit is calculated, except that it's the $50,000, that's a flat rate. If you're a cousin and you are very close to the worker, but you're a cousin, which means I didn't mention you, you have to deal with the estate. Also, we like to call out these two organizations who have scholarships available to the children of workers who are deceased due to employment or who were grievously injured. This one here is called Kids Chance, and you can note the URL at the top left, kcnewyork.org. They give out scholarships. It's March. Everybody's getting accepted into college now and wondering how they're going to pay. I would encourage you to apply for a scholarship. I know they have scholarship money available, and they're a very easy to deal with organization. There is a second organization we'd like to highlight known as the Triangle Shirtwaist Factory Fire Memorial. The Triangle Shirtwaist Factory Fire, which happened on March 25, 1911, that was a seminal incident that gave us workers' comp, actually. And so there is this great fund that is operated by the Triangle Shirtwaist Factory Fire Memorial. They also have a scholarship or two available for students whose parents, one of the parents might have been killed or grievously injured. I'm encouraging you to also visit that website, trianglememorial.org/scholarship. I'm sure you can find it on Google as well, or any other search engine. Encouraging you to visit one or both of these organizations. We're not connected to them, but they are nonprofits. They're doing good work, so we like to call them out. COVID. We still have COVID in this day and age, my friends, and COVID is still payable in the comp system, if you didn't know that. COVID is an infectious disease. Infectious diseases are payable in the comp system. The medical reports are going to be key here. If you want to file a COVID claim, we would encourage you, yes, you think you got it at work, file the claim for sure. Get yourself a PCR test. Okay, remember those tests we used to all go for? Get yourself a PCR test, because that is still the gold standard. That still establishes that you had COVID. All right, if you have a positive test, go ahead and file that. If you don't, see a provider, a doctor, PA, nurse practitioner, who can do a diagnosis via exam to let everybody know that you had COVID. Okay, that's important. And, let the provider know the details of your workplace. Masks? Did you have public contact? Was there COVID prevalent in your workplace? That includes your coworkers, by the way. Prevalent is prevalent because that's the standard we use. Was there COVID in the workplace? Well, then it might be likely that this person got COVID in the workplace because that's the standard we use. Is it likely? We're not looking for a moment in time, okay? We're just looking, is it likely? Now, we do have a bunch of information still available on this, a fact sheet, and we even have a short video. And it's on our website, and this has been out there for almost 4 years now, and we're going to keep it out there as long as there is COVID, I would assume. It's good info. We have all this for you, so please check it out. If you think you got COVID at work and you're within the 2 years, tell your employer, file the claim.
All right, we have another poll, so I will get that launched. Same question as before. Should Liz file a workers' comp claim? All right, here's the scenario. So, Liz worked at a big box store in the seasonal department during the holidays, dealing with the public. Liz fell ill and called in sick to work. Her PCR test came back positive. Liz received paid sick leave for missing 2 weeks of work. She was vigilant about following COVID protocols, wearing a mask, social distancing, etc. Several of Liz's coworkers also had COVID at the same time. So what do we think? Yes or no? Do we think that Liz should file a workers' comp claim?
I'd love to see those numbers. You guys can't see what we see. We see the numbers actually going up. It's like watching a stock ticker, and you're on the right side.
Seeing a lot of yeses, a few nos.
This one, I think I understand why people might go the way that they do.
Mm-hmm.
I have a theory.
All right. Gonna give it a couple more seconds. We're at about 56 responses. Can we get a few more? Yes or no, should Liz file a workers' comp claim? All right, we're at 57, Joe. What do we think?
I think, oh, look at that. We hit our threshold.
60.
Thank you.
Thank you, guys. So mostly said yes. What do we say?
I believe that Liz ought to file a claim, and I believe that we gave you enough information to indicate it's reasonable that she would file the claim. We're not saying she's going to have it established, but yeah, it's reasonable. I think on this one, Allie, people see that Liz received paid sick leave.
Right.
And so they say, well, what is she really going to get because she seems to be okay today?
Right.
All right, that's an excellent point. That's why we wrote the question this way, frankly. So we could explain, remember that I said in a workers' comp claim, medical care is a lifetime benefit? Well, that also, obviously, yes, it pertains to COVID claims, and there are people who are not having wonderful outcomes. They're having what's called long COVID. So you would have your comp benefit available to you for treatment of long COVID. That's on the one side. On the other side, there's the matter of the paid sick leave. Okay. Maybe if she had a great outcome and she was back to work in 2 weeks, she might not qualify for any more money. Fine. However, you know what happens is if one insurer pays a benefit and it's ultimately decided that it's a workers' comp benefit, there's going to be an exchange of money. The insurance companies know how to do this. So don't worry about the paid sick leave. If you think you got it at work, go ahead and file the claim. There are some penalties available, or that might be imposed, should the parties not behave in the manner prescribed by law. For example, The first indemnity benefit, the lost wage benefit, well, yeah, it should be paid within 18 days of the incident or 10 days from when the employer got notice, whichever is later. If it's not, a penalty is possible. Also, let's say you have a hearing, judge makes a decision. There's going to be a date on there where the decision's filed. If benefits are supposed to be paid, they have to be released in 10 days. Or a penalty is possible that is payable to the worker. If you're getting ongoing payments every 2 weeks, your payment is not late until it's 25 days late. That's 3.5 weeks. That's why I'm so adamant about signing up for direct deposit, please, because I just don't see 3.5 week late direct deposits. And also, if a claim is appealed and the worker prevails and the workers do a benefit, our friends in the insurance community, don't forget to calculate that interest that might be due. All right, so you're a worker. You have some responsibilities here. You should try to come back as soon as you're capable. You know, you might be almost fully healed, not quite, but you might be close to fully healed, and the doctor says, you know, you could go back to work with some restrictions. The doctor might give you some restrictions. Like, you know, common things are maybe you shouldn't carry more than 5-10 pounds, maybe you shouldn't stand more than this length of time, you know, depending on your incident. Bring those to your employer because an enlightened employer will bring you back and maybe give you transitional duty. Maybe you can't do your regular job right now, but you can do something else. That gets you back in the workplace, that gets you back to full pay, and that also gets you off of comp, which means that the employer's premium might not be impacted so much in the future because you're off of comp. That's why I say it's an enlightened employer who will do this. This is not mandatory. It's just a good practice. All the studies show it. Also, we have a resource for you workers known as eCase. I'm encouraging you right now to sign up for eCase. eCase is the way that you can see all the documents in your file that I mentioned earlier. Why don't we, let's give that a click there. Because you can see just how easy it really is to register, okay? Bingo. These are all questions you have to answer to register for eCase. It's really this simple, my friends. It's a couple minutes, then you get access, and you can see what's going on in your file. It's a very good thing. You might have a hearing in your claim. The insurer is almost definitely going to be represented by an attorney. You're a worker, you can hire an attorney. You can get an attorney to represent you. You don't even pay your attorney directly. If there is a benefit paid to you, well, if the attorney's getting a fee, it's going to come out of that, okay? If you're not getting a financial benefit, the attorney's not getting a fee. Your hearing would be in front of a law judge here at the board. The judge is here at the board. We are not presently doing our hearings in person. We've been doing them virtually for the last 4 years. And we use something called the Virtual Hearing app. So let me talk to you about this for a moment. We have this Virtual Hearing app that frankly kept the whole system functioning when literally 4 years ago, almost to the day, when we shut down and went everything virtual, we were able to still do hearings. A lot of systems were not. The court system had to shut down for a while. We didn't miss any hearings because of the pandemic. So what this means is, if you have a hearing, I'm encouraging you to use the Virtual Hearing app. You can get it from Google or from Apple. it's a teleconference, okay? Everybody will be on screen for you. If you don't want to get the app, but you still want to do the virtual hearing, I'm still encouraging that. You're going to get a hearing notice. The directions will be right there on it. If you don't want to do that, but you want to participate by phone, the directions to do that will also be on your hearing notice. Spoiler alert, the judge calls you. The judge calls you. You don't call us. Your lawyer doesn't call you. But you need to tell us ahead of time that you want the judge to call you and give us your phone number. Okay, so I am definitely encouraging everyone to please participate in their hearings as well. This is our contact info if you want to follow us in our various social media formats. We have pretty good social media. Why don't you check us out?
Yes.
We don't besiege you with frivolous things. If we're telling you something on social media, it's because it's important. Finally, we're going to leave up the contact info for my office. You can call us. You can email us. Don't be surprised if you get a response in like 5 minutes, because that absolutely happens. It might be me typing your response, because I sometimes take the very easiest questions, but I also get the very hardest ones too. So we're gonna leave this up, and I'm gonna give you back to Allie, because now we're gonna do questions.
Yes. All right. Our first question that we received this morning. Additionally, I'm on this call because we are making our first New York State hire on April 1st. Is there a centralized source to confirm that we are all set for this hire?
All right. Thank you to our friend here who's expanding in New York State. We'd love to hear that. Is there a centralized source to confirm we're all set? Well, there is the Business Express. So I'm going to have to ask you to please Google that one or use a search engine. You would search for New York State Business Express. We have a great deal of resources on that web page, which may, may help you determine if you have everything in place. If you're in the comp, disability, paid family leave world, you can speak to the Advocate for Businesses office. Remember I mentioned I have a counterpart? So that's if you dial that same phone number, just go down the route that says you're an employer and select to get into the Advocate for Business office. They're going to be very helpful on this topic.
All right, so next question we have is if an employee has a pre-existing condition not caused by working conditions that causes them to be sent to the hospital while at work, would their case be compensable?
Maybe, maybe not, okay? Maybe, maybe not. I can't make a decision on a webinar if something is or is not compensable. So just bear that in mind. But pre-existing is something that does come up, but it's not like someone with a pre-existing condition has never gotten workers' comp due to that condition. So maybe, maybe not. If something did happen like that, I'm going to recommend you tell your insurer about the incident, because I'm assuming this is an employer who's filing this question. So yeah, definitely tell the insurer. If you're the worker, well, you can file a claim. You can talk to an attorney about it as well and get an opinion.
When do you expect your settlement after the decision is made by a judge?
All righty. There's a settlement. Now, by settlement, I'm assuming you mean a Section 32 waiver agreement, which is permanently closing your claim. But you know what? I'm not going to assume it's that, because people do use settlement very loosely. Let's change the question, because the answer is the same. A judge makes a decision that the workers due a payment. When's the payment coming? Okay. That's the 10-day thing. You have a hearing. You're going to get a hearing notice. even if it's a Section 32, or if it's a different type of benefit. If you're going to get a hearing notice, you're going to look in the lower right-hand corner. There's going to be a filing date. The filing date will almost certainly be 1 or 2 or 3 days later than the hearing itself. But it's due within 10 days of that filing date. Now, if you've never gotten a direct deposit before, remember I was urging you to be on direct deposit? If you've never gotten one before, we're going to go by the postmark on the envelope. That should be within 10 days of the filing date. If you've gotten direct deposit, you're probably going to get your direct deposit within those 10 days.
Right. Same individual also asked if an insurance carrier appeals the decision, what's the expected time of the appeals process?
Right. I didn't go into that element, Sally, because that also impacts, as in, all right, let's say there's an appeal. This is something we cover in the Workers' Comp 202 in a lot of depth, okay? But let's say there's an appeal. The payer in this instance would be the one who's appealing because the workers do money. So if there's going to be an appeal, it's going to be the payer. They have 30 days to appeal from the filing decision date. So that means there's going to be that period of time between day 11 and day 30 where nothing's happening, there's no money coming. Well, if you're the worker, the best thing you could do for yourself is probably to wait for day 30, because then you want to see if the insurer is going to appeal. They tend to file the appeal on day 29 or day 30, and they don't have to pay while the thing is under appeal. It's a rather unique element of the workers' comp system. They don't have to pay while it's under appeal. Okay, so then there's going to be 30 days allotted for the other side to file a rebuttal. Then it goes into the appeals unit, and it's going to be some months. And that's just the length of time it takes to resolve an appeal. At this point, it's going to be some months after the rebuttal comes in. I'm sorry, my friends, but these are appellate-type instances, and it does take some months to receive it, assign it, research it, and write an appeal.
All right. Next question is related to independent medical exams. Okay, so an IME was requested and performed in May of 2023, and I just was made aware that a second IME is being requested. Is more than one IME a routine component of a workers' comp claim? Also, what if I think the doctor is not the most appropriate specialist to be performing said IME?
Yes, it is distinctly possible and not at all unusual for a worker to go to more than one IME. That is because time passes and you heal, or there might be an additional question that you didn't have examined at the first IME, you might need a second one. This is the kind of thing that happens when someone is temporarily disabled, and periodically the insurance company wants to check in and see if maybe they think that the worker is done healing and is now ready for permanency, permanent partial, permanent total. So that's a very common reason why multiple exams would happen. If you don't think this doctor is the most appropriate specialist, you can certainly bring it up at the hearing that is probably going to result after this test. If you want to bring it up now, you're welcome to try. You're welcome to file a request for action and see if you can get this in front of a judge. If you have an attorney, please talk to your attorney, please.
All right. So next question is, if I am the only one working with no employees, do I still have to get insurance?
No, you do not if you're the sole proprietor. But just want to briefly recall the little lecture you got from Joe about half an hour ago. If you are the sole proprietor, please think long and hard about not having insurance. It is possible. You can buy a policy. What are you going to do if you got hurt at work or worse?
All right, so will the deck be shared after the webinar? We got this a couple times. The answer is yes. We will let you guys know once a recording of the webinar will be available and the slides, and we will email you. We encourage you to sign up for notifications via the Workers' Comp website, and they will let you know when those resources are available to you. But yes. Next question, is the employer notified once the employee has completed the Form C3?
Yes, actually. There's going to be a notice of case assembly, and the employer will get it, yes. I hope the worker is also going to help the worker self out on this one and tell the employer there was an incident. That's pretty important because remember, we want to start that chain of events that yields a claim.
All right, next question. 2 years to file a claim, but 30 days to notify your employer. Please explain.
Well, that is the explanation. Yes, workers should notify the employer, the boss, let's say, okay, within 30 days of an incident, yes. But the worker doesn't have to file a claim within 30 days. And frankly, the worker doesn't ever have to file a claim if the worker doesn't wish, because once you tell the employer has to tell the insurer, or there's going to be a penalty. The insurer has to tell us, or there's going to be a penalty, and that notice will start case assembly. But, you know, let's say the worker didn't tell anybody, or let's say it's a year and 9 months after an incident and the worker is suddenly feeling the effects. That can happen. That can happen. Okay, you can go ahead and file that claim. Yeah.
All right. Are there some instances where lifetime medical coverage ends if you do not have at least one follow-up visit a year?
No, there are not. So, no, there are not. How much transportation is covered per day? The transportation that you need. There isn't a thing that says you can only see one doctor a day by law. No, if you need to see 2 doctors in a day, I'm sorry, you just do. If you need our office's help with that one, the contact info is up on screen. Feel free to contact us.
Next question is, do all doctors treat for workers' comp-related injuries? Can injured workers see any doctor or provider?
Good question. It's a very basic question, but here we go. Let's say there's an incident and we are in an emergency basis. See any licensed provider. Don't worry about who's authorized and who's not. Get the care, protect your health. It's okay. Everyone recognizes that one. Now, it's no longer emergent. Well, we do have this concept in the state of New York called the authorized provider, and you ought to be seeing an authorized provider. You can still get your care from somebody who's not authorized. That can happen, but the insurer can fuss about that if they wish. And sometimes the insurer and the doctor who's not authorized, they can come to agreement regarding paying for the services of the unauthorized doctor. For example, dental care. Dental care is payable in our system, but we don't authorize dentists. So that's a great example of an instance where a provider is not going to be authorized, but is going to get paid for the care. So yes, that is the situation there. Yeah.
All right, next we have, in the event that a worker was injured 7 years ago, does the salary paid then change? I.e., let's say the person was earning $12 per hour and earned $700 per week. The minimum wage increases every year? Is the compensation rate attached to the minimum wage scale?
I'm terribly sorry to say that everything is based on the date of injury. So if you were earning, $400 a week when you were injured in the year 2000, I'm sorry, we're still using that, even though you're now a vice president at an investment bank and you made $14 million last year. I'm sorry, we're still using what was in place on the date of injury.
All right, I think this is in relation to penalties and things like that. What is the amount or penalty amount or percentage?
Well, yes. Each instance that is subject to possible penalty has its own penalty. So there are some penalties that are going to be a flat $50. But there are also some penalties that are going to be $300 and 20%. So the biggest one would be, let's say a benefit was due and the benefit was $10,000 that had to be paid, and it was paid late. Okay, so you're the worker, you're now going to come back and ask for the penalty, and the penalty in that instance is $300 payable to the board, 20% of the $10,000 payable to the worker.
All right, does the employer have to approve reimbursement for travel expenses?
No. I need to say a little more, though. Remember I made a big deal about talking about the difference between employer and insurance payer? Okay, let's say there's an insurance payer. No, the employer does not have a say in reimbursing the worker for travel to and from medical care. The insurer should be paying it, provided that there's a bill in the file. See, workers, here's the thing. Let's say you went to physical therapy 4 times over the course of 4 weeks. If there are 4 bills in the file from the physical therapy, and it was approved and everything else, yeah, they should be paying that. If those bills are not in the file, there's no proof that you went to see a provider for care, so they're not going to be paid. So that means providers, please be sure to file your bills promptly, and that's just a little tip from Joe.
All right. Next we have, what is a PPO provider and the 30-day opt-out? Is it 30 days including weekends or not?
What is a PPO provider? There are some, there aren't many, but there are some plans, some insurance plans that use a preferred provider organization, or PPO. That's a subset of the authorized providers. When we're talking about authorized providers, there's a subset called the PPO, and that means that the insurer has made an arrangement with a set of providers to do care for their patients or their workers' comp claimants, they're called. Okay, that's a PPO. The workers can opt out of the PPO after 30 days. If they wish to, they just file it in writing and say, I'm opting out. You definitely want to file that with the insurer and us. You definitely want that in your file. Okay, I know that that'll come up again. And does the 30 days include weekends? Yes.
All right, we have, what is an IME?
What is an IME? IME, Independent Medical Exam. Remember I was talking earlier about the insurance company could send you to one of its doctors for what's known as an IME, or an independent medical exam? That's what we're talking about. So to our friend here, we did, if this is not ringing a bell, about halfway through the presentation, we talked a lot about an IME. I would suggest you play the recording of this when it becomes available in a couple days, or go back on the slides when you get an opportunity.
All right, we have a scenario here that someone put in. A kitchen worker slipped and fell, hurting her neck and head. She went to the emergency room. The employer never filed an injury report. The worker, now unemployed, has had persistent memory problems and cannot recall when the accident happened. What to do?
File a claim. You're going to need an approximate date. I hope this was in the last 2 years, okay? You could actually probably get the date if you just contacted the emergency room.
Yeah.
Whatever hospital that is, when was I there? They'll tell you. They have the records. There you go. You got your date. File it. If it was within the last 2 years, great. If it was not, still file it. There might be a way to bring the claim in. There are some limited exceptions on the 2-year thing.
All right, we have the failure to notify penalty been waived by the workers' comp board?
Okay, so I think we're wondering if penalties have been waived. Well, you know, penalties get assessed, and sometimes they're assessed, but they're not truly due. That would get it waived. We don't just waive a penalty because we're in a good mood. We don't waive a penalty because we want to be nice. It would have to be because the penalty should not have been assessed in the first place. That's the only thing that's going to get you a penalty waived.
So someone said, if I did not know what to do after the accident, is it okay to report to my employer later than 30 days?
Yes, sure it is. Sure it is. You know what? There are definitely instances where you don't know for 30 days that you've actually been injured. An occupational disease is a pretty good one.
Mm-hmm.
There are some times when the disease doesn't manifest itself within 30 days. Or you didn't realize it was related to your employment. You suddenly realize it. Like Lyme disease. Lyme disease is one of the most common occupational diseases. Okay, maybe it took a while to get the diagnosis. Maybe it took more than 30 days to get the Lyme disease diagnosis. And then then you're going to realize, oh boy, I'm a landscaper. I landscaped that swamp that was loaded with ticks, that Bill and Jackie got ticks. So, you know, that can definitely happen.
Okay. My employer is a self-insured NYCT and NYCT, full stop. Does my employer have to approve reimbursement for travel expenses?
All right. This friend of ours works for the New York City Transit Authority. That's what she's trying to tell us. New York City Transit is self-insured. They have a whole division who handles the claims, or they use a TPA. But regardless, here's the thing. Don't think about your employer as your employer. Think about who's paying the claim, okay? Those are the folks who are going to review the reimbursement. Mel, your supervisor, has no say here. Who's paying the claim? That's the party who's going to review it. And if you submit your 257, your C-257, and your visits are in your file and established, and it ought to be paid, and it doesn't get paid, contact us on screen, either by phone or by email, and tell us. We'll help you with this. We have extremely good luck with this one.
All right, it looks like our last question here. Employers retaliating due to claims, what are the protections?
Okay, and to our friend from the organization who just wrote in, did you talk about employer retaliation and penalties? We're going to do it right now. Thank you for the question. In this system, employers may not terminate a worker for filing a comp claim. In this system, employers may, I'm sorry to say, they may release an employee because they need the employee's job duties performed. So, if the worker believes that the worker was terminated as retaliation for filing a comp claim, here's what you do. You come to our website and you go under Forms. So look at the top. We definitely have a link for Forms. And you're going to get a form known as DC 120. D for discrimination, C for claim, 120. You're going to complete that form and send it in. If you can find an attorney to represent you, go on ahead. You will have a hearing here at the board in front of one of our law judges, in which the facts will be reviewed, etc. The judge has the power and the authority to both reinstate your employment and award back wages. So that is the process. It revolves around the DC 120. You file it. The employer obviously is going to be represented, or the employer obviously has the ability to come to the hearing and make the employer's own case. This is not going to involve the insurer, because this is now worker and employer. And remember what I said, they do have the right to replace you to have your duties performed, but they don't have the right to terminate you because you filed a claim. Thank you.